Hi, everyone. I'm Cooper Knowlton, and I'm joined with Lee Bergstein this afternoon. And we are hopping on the Zoom machine to briefly chat about a topic that we deal with quite frequently. We get a lot of calls from people asking us questions about issues with contractors and people working in their homes, occasionally architects as well. And we wanted to briefly give some advice for people who are potentially entering into home improvement contracts and thinking through that process, and largely focused on how to avoid litigation. I think at a starting point, the easiest way to avoid litigation is to have really solid agreements in place and to think long and hard before you enter into an agreement with someone about who they are and what they're coming to the table with. And so, I thought we would, I'm going to ask Lee a couple questions specifically about a couple of agreements, and chat through a couple of the key provisions that you should think about and make sure are in any home improvement contract. So Lee, maybe just to begin with, what would you say to someone who is potentially considering entering into an agreement with a contractor, who comes to the table with a one-page agreement, or maybe even doesn't even have a standard form agreement?
Yeah, so that, more than many other industries, is just a major red flag in the construction industry. More than anything, because there's this really available resource that has every type of contract you could possibly ever need, the AIA contract. So because of that, there's really no excuse not to have a contract. This is one of those situations where you have to go on Google and scour the internet for a contract. They're really readily available, and there's a reason why they're at minimum 7 to 8 to 9 pages. These are expensive jobs with a lot of variables at play, and they require at minimum a 7 to 8 page contract. Some jobs require a far longer agreement. So I would say, one, request that they use an AIA contract, and two, find out why they don't offer that from the outset.
Do you think there are any legitimate reasons for why a contractor might not use an AIA agreement?
Well, there are legitimate business reasons for a contractor to not want to use it. It gives way more flexibility during the term of the project for the contractor. It sets less obligations for someone who doesn't want to get a lawyer involved. It's less clear what the rights and responsibilities are of both parties. So there are business reasons for it. Without getting too into the weeds, there is law. If you're doing a home improvement project, certain elements have to be in your contract. So it's possible that a contractor might be violating that law by not using the AIA contract, depending on what their form is. I think that there are plenty of reputable contractors who have longer custom contracts that are not AIA contracts, because they want their own custom contract, but they still incorporate many of the key provisions into that contract.
Right. Yeah, certainly. I mean, I think just we very frequently, when someone does approach us with an issue related to a general contractor, it's never the case that the agreement that they have is more robust than the AIA agreement, right? It's almost always that the case that the agreement is very short, very insufficient, and there are problems with it. The minute we see it, we can often tell that this is not a they haven't contracted in the right way, and that often is, like you said, it's a major red flag, and it shows a willingness to cut corners early on in the job, and that frequently leads to more corner cutting and more issues down the road. So with that sort of major point out of the way, there's a couple key points that, whether you're using an AA agreement or a contractor is approaching the conversation with something bespoke, I think the most frequent issue is going to be payments, right? The most frequent issue is always about money. And so maybe you can sort of get into a little bit of detail, Lee, about how the AAA form and how a solid agreement should think through payments, because usually it's not the case where a payment is just made for one of these jobs at one time. There's usually multiple payments that are done throughout the course of the job. And we frequently hear contractors who are saying to people, I need more money. And that's often where, the dispute begins. So maybe you can sort of get into a little bit of the weeds on how to think through that issue.
Yeah, sure. But by the way, I just wanted to say one thing. We're using the phrase AIA as if everybody knows what it means. It's the American Institute of Architects. And if you're watching this and your contractor says, I don't know what you're talking about, AIA, you can just go to aiacontracts.org, and all the contracts are there, and you can buy it and pass the cost on to the contractor. It just requires filling in the blanks. But you were mentioning payments. This is, payments and on-time completion are really the two biggest issues that our clients and everybody face when they have a job, whether it's residential or commercial or even bigger projects, right? Is the project on time and on budget? Those are the critical provisions. So what the AIA contract does is it provides for progress payments that are typically reviewed by an architect if you have an architect in your project, and most bigger projects do. We're talking about projects north of $50,000, $75,000, $100,000. Typically, you're going to have an architect who drafts plans. And the architect basically serves as the owner's rep. And as work is done, there are applications for payment that are made to the architect, and the architect will take the plans, review the work, and ensure that the work is on time and on budget. And then they get paid. So that's, and there are different ways to structure that. If you have a smaller job, you might not want an architect, but you can still have someone designated as kind of the owner's rep, or you can be the rep and put some language in the contract that protects you to ensure that the contract's being done on budget and on time.
Right. Having that third party is crucial, because certainly it's very hard for the layman to have any sense of whether there's 20% of the project has been done or 40% of the project has been done. And so having a neutral third party, or maybe not a neutral, but having someone who can step in and help sort of wade through some of those more complicated construction related issues is extremely helpful. And setting those expectations from the beginning too, so that the contractor understands that there's someone else. And we do frequently see situations with contractors who try and take advantage of people and tell them that I need more money and I need more, that a larger percentage of the job has been done, and want larger pieces of money when things start to go south.
I need more money is the most common reason why a relationship ends in an owner contractor situation. If there's nothing in the contract as to what happens in that situation, it becomes very difficult.
Sure. Do you have any thoughts, Lee, on how to handle change orders?
Yeah, so the standard AI contract has a provision for that as well. It designates who's responsible for filling out the change order, the procedure by which both sides have to agree to both the scope of the change order and the price for the change order, and the mechanism by which disputes around the change order are resolved in a way that obviates the need for expensive legal interaction. So yeah, the change order is kind of the cousin of the progress payment, because that's the most often reason why work slows down or why the price goes up.
So another key provision in the AAA form is the liquidated damages provision. And the liquidated damages provision is largely left blank in the standard form agreement, and it sort of says for you to fill it in yourself. So maybe you could briefly discuss first off what a liquidated damages provision is, and then say what you would advise someone who's putting together one of these agreements to plug into that section.
Yeah. So the purpose of liquidated damages in the construction context is to figure out, typically is to figure out an amount certain that would compensate the owner in the event that the contractor is late in delivery, right? Because typically for the types of projects we're talking about, you can't live in your house, or you can't use a substantial part of your house, or in the commercial context, you can't open your business unless the work is substantially done. So there's a real value number that you can attach to on-time delivery. And by negotiating a liquidated damages provision that you feel, one, will adequately protect you in the event that it's not on time, but two, will be sufficient incentive for the contractor to ensure that it's on time so that they're suddenly not losing money on the job, can be a really powerful tool, and one that more than almost any other provision in the AIA contract is going to require some negotiation. You're going to get pushback on it. If you're picking the right number, that means that the contractor is not going to be happy with it at first. So it requires some real back and forth. But ultimately, if you have a reasonable enough contractor and they're confident in their schedule, you will get to that right number. If there's a total unwillingness to provide a liquidated damages amount, then you have a contractor who probably is over promising with respect to delivery, and maybe the recourse is, okay, you don't want to do this, give me a more reasonable date and let's change the price to reflect the more reasonable date.
Sure. So the last provision that I wanted to discuss was the termination clause, or so that it's termination / suspension, suspension of work. Maybe you can briefly chat about what to think through. Again, this is one of those things that you don't want to address at the beginning of a project. You're chatting with someone that you're likely going to be working with for months, if not years, and you really want to have a good relationship. But it is important to think through what it looks like in the event that you need to terminate this individual. So how do you think about approaching that section before you've formally even started work?
Well, like we talked about before, the AA contract has this provision built out, but whether it's for cause or for convenience, who's doing the terminating, is it the owner, is it the contractor? It has all of that spelled out, and the mechanism by which it happens. I'd say 99% of owner contractor disputes that result in litigation, someone gets fired, right? It's you're talking about a breach of contract case, someone's getting terminated. There are other cases, negligence cases, et cetera, that happen after a contract is completed. But for the purposes of what we're talking about now, someone's getting fired. And if the contract is missing provision as to how that's accomplished, how that takes place, then there's a lot of ambiguity left once a lawsuit starts. Was the contractor fired for a legitimate reason? Were they fired at all? Were they fired for convenience? What happens to the money that was owed at the time of termination? What happens to the owner who has to come out of pocket to finish the work? A good contract is going to think about all those things and spell out what happens. And unfortunately for us, reduce the need for lawyers. But that's kind of the purpose of a good contract.
Sure. Yeah, this has all been hugely helpful and interesting to think about. If you are having any of these issues, certainly feel free to reach out to Lee or myself. We've chatted with a lot of individuals who are in this unfortunate position, and oftentimes you may be in the position now where it's too late to go back and have the AA agreement in place, but hopefully there's some people out there who are watching this who can avoid some mistakes by catching this video. And if not, and you potentially need to consider litigation, certainly feel free to give us a ring and we can chat through some of these issues in more detail.
And Cooper, I'm very happy to see that you have a TV on your wall in the background. For the first 5 years of my life knowing Cooper, he was TV-less in his home. So it's good to see TV there.
I strategically placed it there. It's just
I thought.
just a cardboard box.
All
All right, Lee. I'll catch you later.
Bye.